All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, welcome. Weekend Appointment with Attorney Carl Rominger, the show where I answer your legal questions. And I want to just touch base for 1 second. Pennsylvania Supreme Court turned down a challenge this past Monday, which would have overturned the Philadelphia ordinance that requires handgun owners to report lost or stolen firearms to police. And they also upheld restrictions on gun possession by people subject to a domestic violence order and those ruled to be a danger to themselves or others. Basically, in a one-page order, they just turned down two lower court rulings that allowed for such ordinances by Philadelphia. So they kind of chickened out and didn't speak on the issue. I don't know why they didn't do that, but that's interesting. Tom, you're on with Carl Rominger.
Oh, how you doing, Carl?
Good, Tom. What's your question?
Okay. My father went into a nursing home facility, okay, because he needed some rehab to recover from an illness, and now that he's about ready to be released, and I'm for some reason I have all kinds of social service people involved in his release, and it seems strange that he can't check out of a nursing facility on his own accord after a doctor's approval. I noticed in Maryland law they allow you to check out to return to home. He wants to return to his home, and my sister lives with him. And I wonder if you can give me some insight on why Pennsylvania doesn't allow you to check out of a nursing facility on your own accord.
Well, he would technically be allowed to. Has he been declared incompetent, or is there a court order or some such thing in place?
No, there's not. When he went in, he was declared incapable, but his situation has improved to the point where he can feed himself and he can walk reasonably well. But they want to come in and do a home inspection and make sure, see how he gets around and things like that, but before they release him.
Who, when you say declared incapable, who made that declaration?
They made that at the nursing facility. It was probably the physician assistant or his doctor.
All right. My understanding, and maybe I'm wrong on this, but my understanding is that the patient has the absolute right to refuse treatment, but if they're declared incompetent, then they can't refuse treatment, obviously, because somebody else is going to make those decisions for them. This determination of incapable, I'm not familiar with the concept and understanding if that would have a legal effect on his ability to leave, or if you're just being told this. In other words, if you were to just load him in the car and drive away, I suspect they can't detain you. I wouldn't do that literally at this point.
Well, there was a case in Northumberland County where a person did exactly that, and the patient was returned to the nursing home, and the son was arrested.
Yeah, and I'd have to take a look at that, because the next thing that could happen is if a court order's gotten restraining you, obviously, then you would be in clear violation of law, or if it wasn't in the person's best interest. My advice would be, if you were in my office right now, what I would do is I would sit down and I'd say, okay, who's involved? We write down all the names, and I'd start making some phone calls. And I've had this with children and youth before, where I've gotten on the phone with them and they're saying, well, your guy's got to do this, this, and this. And I'm saying, well, I'm telling him to go get the kid right now. Well, you can't do that. Well, I'm telling him to go get the kid right now. Click. What ends up happening is they have to go run and get an order filed, or they've got to choose. I'm not certain in this situation. I would let them, I basically say, hey, this is what I'm going to counsel. And if you've got some law or authority that says we can't take that out, then give it to me. Otherwise, we're coming over, and I put it in writing. But at that point, go ahead.
Yeah, to me, it seems like they're just running up the bill. We're paying for the care out of his funds, and
Right.
And every time we have a meeting, it's like no, he won't be released until 6 weeks, or he won't be released until 8 weeks, and so on. That's the way I view it. Is they're just running up the bill.
And let me explain it this way. That you always wonder about that, but I want to make sure you understand the way I would counsel to take action in a case like this is to have me or someone like me contact them directly and demand to say, hey, we're done, we're ready, we're leaving, and feel the situation out. I would never counsel anybody to just literally run off with the person before we've had a chance to kind of look and see what restraints might actually be in place. But like I say, best of my knowledge, off the top of my head, I'm not certain that without a court order they can stop you.
All right.
But they have the ability to get a court order very quickly, usually in those situations. In fact, there's usually a judge that they can get by telephone to give a verbal. So my point being is it's better to feel it out a little bit ahead of time and find out how firmly they really believe about this. The other thing, though, and you need to remember this too, there are times, and part of the reason why they're crawling all over the place is there are times when people try to pull a relative out of a home for no other purpose but to save money when clearly that care is needed. So there are some mechanisms in place, and that might be a good faith dispute. I mean, care might not be needed. It might be needed. In some cases, it might be very clear that one side's in the wrong. But as you can imagine, there are times when some family member will roll up and just try to take Uncle Bill off,
right
into the sunset, and it's not really in his best interest. And then the question is, are they doing it to save money, or do they just want access to his Social Security check? What's really going on? So there's a lot of legitimate reasons why the government is digging in here.
Okay.
That doesn't mean they're right, though.
That's what I thought, because I looked in family law dictionary, and it says you can check out of a hospital on your own accord if you don't want the treatment.
Yeah, if he's competent, it's up to him. That's the way I view it. But again, I would want to take it in a measured circumstance, and I'd also want to go meet him. I'd want to, as the attorney, I'd be particularly interested in evaluating his capacity myself, so that I could say when well, do you know what he's really like? Have you been out to the? And you say, yeah, in fact, I was there. I was there a couple hours ago, and this is what he's really like.
All right.
Does that make sense?
Yeah, that makes a lot of sense.
All right, Tom.
I appreciate your insight.
All right, in the future, if you have any other questions or anything, feel free to call into the show or go to weekendappointment.com.
All right. I really appreciate what your stand on gun rights too, and your assistance on that.
Well, thank you very much.
Okay, thank you very much, Carl.
Take care.
Bye.
Weekend Appointment here. I'm attorney Carl Rominger answering your questions. This is our bonus edition. Don, you're on with Carl.
Yeah, hey, good afternoon, Carl. I appreciate this extra time you have.
Yeah.
I'm calling about a construction contract that I signed for some home repairs, $2,500, okay?
Okay.
The contract states that the work would, approximate start date May 30th, approximate completion date June 15th. There's also a contract a clause in here that states that if the buyer prevents the contractor from beginning the work on or after the approximate start date listed above, the buyer will be liable to pay the contractor for all costs and expenses incurred arising out of or in connection with the delay, but including but not limited to the execution of this contract, preparations and purchases made for the work, plus the contractor's loss of profits. The 15th is Tuesday. The guy has not called, and quite frankly, I found another contractor that's willing to do the work for $500 or $700 less.
Right.
Is this? If he doesn't show up by the 15th, which is Tuesday, suppose he calls me, in a few days after that. Do I still have a right to say I found somebody else?
Well, you're saying the 15th is the completion date.
It says approximate completion date, right. It doesn't say, it's not a firm date.
And is his approximate start date has gone and passed as well.
Oh, absolutely.
Yeah. So,
You know, and I was home the whole month because of a problem that I'm having, a medical problem.
right.
I figured they'd be here sometime during May. You know, but or not May, but May, the first week of June anyway.
Don, what I'm going to do is I've got to take an imaginary break here, so we can go into the next segment. I'm going to answer your question then.
All right, that's fine.
All right, you listen to Weekend Appointment with attorney Carl Rominger. Welcome back. You're listening to Weekend Appointment with Carl Rominger. If you don't know me, I'm an attorney here in the Mid-State answering your legal questions. Don, still there?
Yes, sir.
Okay. Don was telling me in the last segment, if you probably heard, but if you didn't, he has a contract where it appears that the contractor has blown the approximate completion date and blown the, will soon blow the, I should say will soon blow the completion date, but most likely blew or did blow by the start date, and you have no work performed whatsoever at this point, I understand.
No, nothing, and the guy hasn't called, and quite frankly, I don't want to call him because I found somebody else.
And my next question for you is this. At this point in time, have you paid him any money?
Oh, no. He wants the balance at the end of the job, which is good, you know.
Right. So there's no money exchanged.
Absolutely not.
And arguably that means no consideration has been exchanged. In other words, you haven't done anything or given him anything in exchange for the contract except presumably your signature.
Right. And it says, it's right on the contract, it says payment upon completion.
So without consideration, we might argue that there's no contract, but that's not an argument you're always going to win. So the next question is can you call it an anticipatory breach? And the answer is, if he had an approximate start date and an approximate completion date, even though they're both quote approximate, I think you would be fair to presume that the approximate start date has been blown and that there's no way he's going to meet the approximate completion date, realistically.
Well, theoretically, if he starts the job Monday, he could probably finish it on Tuesday or Wednesday,
okay,
which wouldn't upset me. But I haven't heard from the guy.
Okay.
I don't think they're going to be here Monday.
And so could you breach it at that point? It's time of the essence. And the short answer is it doesn't sound like the way the contract is written that time is of the essence. But I think you may have a defensible position. What I would do is if he blows that day, that last day to do it, to be complete, I would just go ahead and send him a written letter that just says, I've terminated your services, thank you.
That's what I was thinking of doing. On the 16th, maybe.
Yeah. I think you're fair at that point to say that it appeared, and you documented, or at least you've told me, and you can document this in your letter, that I called you and never received a return call.
Okay.
Because you did call him at one point, as I understand it.
Well, I called him. I had some other work that I needed a quote on, and I had talked to him, but I didn't. I mean, he came and gave me the estimate, said he'd be doing it in this time, and it sounded, very good and so fine, and I wanted the work done, but, I'm going to save some money if I get this other guy to do it.
Right. And so, you got to balance that out, but the short answer is I don't think you're in imminent danger. It doesn't sound like this guy's particularly interested in this contract if he hasn't.
I would agree, and he's actually hiring a subcontractor who may have looked at the job and said he doesn't want it, but, I haven't heard from anybody right now.
Right.
So.
Yeah,
right.
I guess the answer is, how long do you wait and what's reasonable? Under the circumstance, since there was an anticipated start that's been blown, I think, a lot of time's starting to pass here. And the reason I asked you about the length of or was asking you about, and you were saying it's only a couple days to complete this, obviously, if it was a multi-week project, your position would get stronger and stronger because it would become less and less possible for them to complete it.
I believe it's a 2-day job at the most.
And sometimes in a contract, you're looking for magic words, which are time is of the essence. And I'll quote it again, time is of the essence. When you see those words, that means that the contracting parties have agreed that the timing is very important and is of the essence of the contract. And I should point that out, that time is usually not presumed to be of the essence. It's assumed to be approximation. So if I tell you I'm going to have everything done by the 15th, and I don't, but I have it done by the 17th, it's probably okay. If it says time is of the essence, then it's clear that that's a drop-dead deadline usually, or at least that those time frames are extremely important to the parties. Here, though, because it's not just a completion date, there's an anticipated start date.
Right.
It seems to me that you've got so much time has passed that you would have presumed they would have started, that you've got more wiggle room to say, I'm going to jump the gun and say if they're not done by the 15th, they're never coming.
That's my thinking on it exactly. Plus, I can save about $600 or $700. And then, can he come back on me for expenses of any kind?
Well, the long and short of it is, if he's breached the contract, no.
Okay.
And that would be the battle. Now, of course, both of you would probably bear your own attorney's fees in a contract battle, unless the contract has terms in it that speak to attorney's fees. So, if it has no attorney's fee clause in it, then in order to fight you for that money, he'd have to hire an attorney and sue you or otherwise litigate it.
Yeah.
And it probably wouldn't be worth his while.
No, this isn't a big job in any event, but it's something we want to have done, you know.
Yeah. No, Don, I think you're fine.
All right. Hey, I appreciate your help, Carl.
Hey, no problem.
I really enjoy your program when I get a chance to listen to it.
Hey, thank you for listening. If you want to hear a playback of this, it'll be on weekendappointment.com as well as WHP 580.
Hey, thanks very much.
All right, take care.
Bye-bye.
Oh, boy, oh, boy, oh, boy. Contractors, contracting. You got to read those contracts carefully. The fact that there's no money put down on the contract, even $1, if you think about it and you think through all the times that you see this deed to your child for $1 or this contract was signed for $1, that's called nominal consideration. A contract has to have this magic element in it called consideration, which is even a peppercorn, as they used to say in law school. So the exchange of value has to have a mutuality to it. So a contract traditionally, if only one side gave something up and the other side gave up nothing, then we would say there's no consideration. Now, some states like New York State have a statute that say that your signature is your consideration, and that creates a binding contract. But it is a defense to say that a contract is not a contract that's binding on the parties if there's no consideration exchanged by one of the sides. So, for instance, if I came to you and I said, I'll give you $500 to cut down all those trees up there and take the wood off of them, and we signed an agreement on it, and then we tried to modify the contract, and you just said you can only cut down half the trees, and that's the new contract, I could say there's no new contract because I didn't get anything, even if I did agree to that. But if you lowered the price and I got to keep more of my money, or you gave some back, then the considerations have changed, and we would say that there is a new contract and a redoing of the agreement of the parties. So, long and short, what Don had there is a contract that's probably binding and probably is being breached, and he can then do what's called an anticipatory breach, where he basically calls the contract off or cancels it unilaterally without the other side's individual or immediate assent, and a court will probably say he was reasonable in doing that because he needs to get something done and the time frames have been blown, and that is a reasonable position. Contract, however, is very important. The reason the law holds people to contracts, that's what allows civil society to move forward, what allows the economy to move forward. You know that when you buy a bond in a major auto manufacturer, maybe not. When you buy a bond, generally you're going to be paid first before the stockholders are and before the employees are. And so a bond has a certain security interest in it that you wouldn't usually find in a stock or other thing. And I think I'm going to have to go into break here for a moment, but I can't tell because Windows is obscuring my computer screen so that I can't see my timer. But what do I got left here? About 20 seconds, Shane? 2 minutes? 2 minutes? Oh, 2 minutes. Okay. Want to also remind you to go to weekendappointment.com whenever you get a chance. Check it out. We have the free will program, which allows you to get a free will. I encourage you to fill out the paperwork, send it back, and also I'll talk to you about a living will and a power of attorney when you come see me. And it's a real live appointment with a real live lawyer, myself mainly. Also, I'd encourage you, if you're not, to become a member of Facebook and friend me there, so you can keep up with our shenanigans throughout the week. I do post regularly to weekendappointment.com. My Twitter feed shows up on there, and my Facebook page is updated. And I've been able to answer a lot of legal questions on Facebook for folks, and I enjoy doing that. So if you get a chance, feel free. Also, it lets you give a little window on my personal life if you really care about that or not. It's not that exciting, and I try to keep it a little filtered. You don't need to know everything about me, I'm sure, nor do I need to know everything about you. That said, I enjoy doing this, and that's why I give away those free wills on weekendappointment.com, and I'm hoping that you take me up on that. The other thing I'd ask you to do is register there so we can keep you updated with regular emails about updates in the law. I'll see you after the break. Welcome back. Carl Rominger here with Weekend Appointment. It's a show where I answer your legal questions, take your calls, bonus podcast edition. And what do we got going on right now? Well, don't have any callers at the moment, so I'm just going to kind of do a little monologue here like a real talk radio pro would do. Of course, I'm not a real talk radio pro, so beware. O.J. Simpson was in his favorite place, court. Can't anybody get away with murder anymore? Why do I say that? Well, I say that because, got O.J. Simpson. He gets away with murder, and what's he do? He managed to get arrested for stealing baseball cards and something like that, along those lines. And then my old friend, Mr. Vandersloot, down there with Natalie Holloway, got away with murder, at least what we think. And then he goes 5 years to the day later and kills a girl in Peru, allegedly, of course. But I'm told that you can see some surveillance footage of him coming out of his hotel room, looking around, kind of, oh, okay. And then goes down and says, "Don't disturb my girlfriend. She's sleeping." And then disappears and wonders why he's going to be caught later. He probably should have lowered himself out a rope out the window and out the back and got the heck out of the country. But obviously what I'm learning here is that karma catches up with you. And maybe that's what's happened to Mr. O.J. and what's happened to Mr. Vandersloot. But nonetheless, O.J.'s been in court. What O.J.'s been doing is arguing that he did not receive a fair trial. And I feel for him in a way because he was just trying to get back some of his own stuff. Of course, I'm not sure why he needed to get back his own stuff because it was just going to end up going back to the Goldman family anyhow. But they argued in court recently that the trial judge gave the jury the wrong instruction, wasn't fair to Mr. Simpson, and that he was clearly overcharged. And the justices at the Nevada Supreme Court apparently noted during the oral argument that the people Simpsons were with were armed and they posed a risk to the victims. Now, nobody was actually harmed, and they were also arguing that there were no black jurors and that the two potential black jurors were excluded because the likelihood of conviction would have decreased and that was prejudice. The prosecution saying one of the black jurors was disqualified because her brother had been sent to prison for 3 years and she believed he was wrongfully accused and she appeared to be a Simpson supporter. The other juror, they claim, flip-flopped on her answers and was struggling with judging another person. It's interesting, and you got to know that O.J. has a pile of money that comes in every month in the form of a pension, which he's allowed to keep as his monthly income from a pension because that's not something that they can reach and has bankruptcy protection. So he has lots of money for his lawyers. And I wouldn't be surprised if he's not completely out of the loop yet. And he may get a new trial at some point. I've seen some issues in that case, and I've only followed it with half an eye. But it does appear to me that O.J. Simpson could get a new trial. So we'll find out here because it's now in the hands of the appellate courts. Of course, in the meantime, like I say, nobody seems to be able to get away with murder because they always get arrested for something else later. David, you're on WHP with Carl Rominger.
I have a question. In the state of Pennsylvania, what are the living trusts? Are they valid? Are they good for the state of Pennsylvania?
Yeah, great question, David. A very good question. I have people that roll into my office, and they will bring me their living trust packet, and they've gone to some hotel somewhere, and they've sat down and listened to a seminar, and a living trust packet's been prepared, and it only cost them $1,500 per husband and per wife.
Ooh.
And they're very happy with it, and they're very proud of it. And it comes with spillover trusts and wills and all kinds of documents. And I look at it, in most cases, I can't find a need for it, because here's why. A living trust does not protect your assets from Medicare. Because a living trust is always revocable, and anything you can reach, the government can reach, is the way I always like to say it. Mm-hmm. Number two, in Pennsylvania, our probate system is not this crazy, esoteric, backward system that actually does exist in other states. And the living trust assets are still assets that have to be included in the estate tax return, because they still count as assets of the decedent. Now, they'll flow outside of the will, okay, because of the trust aspect, but they won't fundamentally change what the probate lawyer has to do or what the heirs have to do, for the most part. So at the end of the day, I see very little practical application of a living trust to a Pennsylvania probate situation. Now, on the other hand, I have a little bit of experience with family members from New York State, where the probate can be intensely complicated and technical, and removing assets from the probate through a living trust mechanism prevents those little quirky rules of the New York State Probate Court from coming into play vis-a-vis those assets and tying them up for lengthy periods of time.
Okay, that sounds like it's not worth it then.
So now, and of course, what is worth it is a good will and a series of potentially irrevocable trusts, which can be created, particularly for people who have a small to a large amount of wealth who want to preserve it for the next generation. But the living trust vehicle is not going to help you preserve it for the next generation the same way that a irrevocable trust could.
Okay. All right, that answers my question.
All right, David, thank you very, very much. And again, if you ever need anything else, don't hesitate to go to weekendappointment.com. You can look me up there. You can look the show up there, and we always like to have you sign up as a user.
Okay.
All right, thanks.
Thank you.
Carl Rominger here. If you'd have just joined the show, I'm an attorney here in the Mid-State answering your legal questions. We do it live on the air, and we do it during the bonus podcast edition. And I think I was just talking about when I was so rudely interrupted by that caller. I think I was, right? Oh, the callers are bothering me. I was talking about O.J. Simpson, and I guess saying I wouldn't be surprised if he managed to get a new trial. So what else did I want to talk to you guys about? Well, I'll talk probably in the next segment here. I'm going to talk a little bit about the United States Supreme Court and what they've been up to, and just want to let you know. I just want to let you know that obviously there's going to be some big changes in the Supreme Court, and there's some major decisions yet to come down, and I'm going to talk about those again, like I say, in the next segment here. Shane, how much time do I have left in this segment? I got 3 minutes, so what do I want to talk about? I did get one on Weekend Appointment. Guy had put a question in on weekendappointment.com, and I'm going to answer it online for him, but just orally here. He said he was solicited by somebody who works for a outfit that would help him lower his mortgage interest rate, and they would advocate for you, and you pay them some money, and they get some lawyers and other people involved, and they go out and they negotiate with the banks, and they told them because they have tough lawyers on staff, they'll get you a better interest rate because they have firmer negotiations. Well, I don't know what that means, and I don't know if that sounds like a great idea. The answer is banks are going to give you a loan based on your credit rating, your credit worthiness, their risk tolerance at the moment, and the current interest rates that are available to them through different vehicles out there. So I don't see how having a, quote, tough attorney negotiate it is going to any way, shape, or form change the availability of a good interest rate or a better interest rate for you, nor do I think paying a lot of money to somebody to go out there and do that's a great idea, particularly when you can go to a local mortgage broker. And one out of Carlisle that does the Mid-State is Foot Capital, and you can find them on weekendappointment.com. They are a good, solid outfit. So is anybody else who's a mortgage broker, and you can have them go and look for a loan for you, and they're not going to charge you anything until they find you a rate. And that's their job. A good mortgage broker goes through all the different lenders and tries to fit you with one who's offering the best rate and terms for someone in your particular situation. So in all seriousness, I would strongly counsel against a outfit that solicits you, but I would go with a local reputable mortgage broker. And that would be the best way to do it. So that's my answer. I'm going to post that to that fella on weekendappointment.com. Hopefully he's going to listen to this show. But even if he hasn't, he'll have his answer. And it goes, again, throughout the week. If you have a legal question, you want to meet with me in my office, you want to go over some things, just go to weekendappointment.com. You'll find my information on there. I'm Carl Rominger. I'm an attorney here in the Mid-State. And I really appreciate the people who have posted on there, because what we have done is create a little knowledge base. We've got about 800 questions and answers on there over all different topics. And if you want to get a chance, you can go there, look over those different topics, and find out the answers. So I think I'm ready for break here. So I will see you folks in the next final segment here. Welcome back. This is the last segment of the bonus podcast. That's our friend from New Jersey. Little Bon. Is that Bon Jovi? Of course that's Bon Jovi, isn't it? Yeah, it's not Steel Horse I Ride. Oh, I'm pretty sure that's Bon Jovi. If it's not, shoot me. I know it's Bon Jovi. Come on. All right. Carl Rominger here answering your legal questions on Weekend Appointment. This is the bonus edition, and if somebody calls in, I will, of course, put them on the air here with me. If not, you're just going to have to listen to me talk it up here for a few more minutes. And like I said before, I'm not a talk radio professional, so I don't quite have that Rush Limbaugh, Sean Hannity ability to talk for 8 minutes straight, although I've done it to some poor juries over the years. In fact, I get to stand there for about half an hour and just kind of talk at them, which is very frustrating to me because I would like the jurors to be able to ask questions. And I think that jurors can ask questions, that the courts just don't tell them that. Now, I've had a few judges over the years tell jurors, you can't ask questions right out of the gate. I've had other judges say nothing to them, and then when a juror tries to ask a question, handle it. But I have also had jurors ask questions when, like, for instance, one raised his hand and everybody looked around. The judge said, well, what is it, sir? And he said, well, I have a question. He said, well, why don't you ask your question? And then one of the lawyers will repeat it to the witness. And, of course, obviously that was an interesting question, as it was interesting to know what they had to say. And, of course, military jurors can ask questions, just as judges can ask questions. Annoyingly, sometimes judges can ask questions. Nothing better than when you've got your case perfect. You've got the prosecutor on the ropes because the dum-dum forgot to ask a really good, important question on an element. And the judge goes, excuse me, sir, but I haven't heard any testimony on this. Could you fill us in on? And, of course, the judge is dutifully helping out the opponent. And it drives me crazy. Of course, and they never do that for the defense attorney, do they? Maybe they do once in a while. So, but the judges want to make sure that people don't walk in or out of court with a unjust result simply because somebody forgot to ask an important question. Although some judges feel that they should never interfere. Others take it upon themselves to interfere routinely in lawyer questioning. And, of course, you got to know that when you go in the courtroom, which takes me all the way back to juror questioning. And so if I were on a jury, let me tell you what I would do. I would do a couple things. If they ever let me on a jury, one of the first things I would do is raise my hand and start blurting out questions during trial and make that judge tell me I'm not allowed to ask questions. Because I think if people knew that they could try it and do it, they might. That's what I would do. And I could also tell you that if I was on a jury, I'd send out a question on nullification. And I've told Bob Durgan this before. I would send out a question along the lines of, hey, what if we think that this marijuana law is unjust and that marijuana should be legal? Are we allowed to ignore the law? And, of course, the judge instructs you have to follow the law, and that he's the sole source of the law. But technically, you have the right of juror nullification, which is the right of the jury to come to any verdict they want in terms of a not guilty. Can't find somebody guilty because you don't like the law, but if you want to nullify the government's action because you feel that the law is being applied is unjust, you would be following in the footsteps of the jury who went over this guy William Penn's case. The guy named William Penn has something to do with Pennsylvania, and I'll let the history buffs fill you in on what William Penn had to do with Pennsylvania. But Mr. Penn was on trial, and the judge ordered the jury to find him guilty so they could put him to death. And the jurors disobeyed the judge's instruction on the law. They even arrested some of the jurors, and they held out. And so Pennsylvania was founded by a guy who was the beneficiary of jury nullification. So I'm always curious about that and why our court system goes apoplectic about it, because, of course, they say we have the duty to apply the law, and we are the judges of the law, and you, poor jury, are just judges of the fact. But they can't tell you that you can't nullify, because you do have that power, and it's recognized by the law. In fact, jurors are even allowed to reach completely inconsistent verdicts. So you could reach two completely inconsistent verdicts that are mutually exclusive of one another, and the courts will say, well, that's the province of the jury, just as jury nullification is the province of the jury. So if I was on a jury, I would have a lot of fun just trying to create little legal textbook problems for the law school students. But alas, nobody will ever, ever, ever let me on a jury, particularly after they hear this podcast. So I think I've kind of axed myself. Shane's nodding his head. He's like, oh, yes, you have. Oh, yes, you have. So what else do we want to know about juries? Well, jury duty is your job as a citizen, just as you could be drafted to war. You can be drafted to stand in judgment of your fellow citizen. And it is an important duty, and it's something you should take very seriously, both for the government and for the litigants involved. And, of course, you can be on a civil jury where it's just a couple people fighting over something silly like a little bit of money. And, quite frankly, you see that more than you would imagine, where people fight over small amounts of money and eat up lots of court time. But most civil cases settle. So if you end up on a civil suit, you're probably going to end up on a medical malpractice case. And why wouldn't a medical malpractice case settle? An interesting little tidbit. Doctors do not have to settle their claims. And what do I mean by that? Doctors, unlike a lot of other professionals, have the ability to withhold consent to settle with the insurance company because that affects their medical reporting. And it goes on their permanent kind of record. So if they want to get hospital privileges and things like that down the road, their malpractice claim shows that it was settled or that money was paid in a jury verdict. So they sometimes withhold that because they have that right to. And as a result, you sometimes end up with medical malpractice trials where with another professional who didn't have that right to hold out, the insurance company settles out from underneath them. Also, medical malpractice cases are often decided in the defense's favor, despite the theory and the claim that doctors are leaving the state left and right because of medical malpractice. In fact, most medical malpractice cases are non-starters and they're not settled, and doctors do not pay out big bucks on them. In fact, most medical malpractice cases in the central Pennsylvania area are defense verdicts entirely. So, and going back, that's what you most likely end up on. So if you do... Oh, I'm laughing because somebody just commented on my new Facebook photo about me breaking my neck in Florida, because I think when looking through the microphone, it looks like I'm in a halo. Halo. You know about that halo thing? When you break your neck, and I know this because I've done personal injury work for people that wear these horrible things, and it holds your head while your neck heals. So if you have a neck fracture, you have to sit up for weeks or months at a time with this giant halo around your head that kind of is drilled into your skull, holding you in place. Oh, yeah, dude. I've seen the scars even. 2 on the forehead and 2 around the back. Not pretty. And you know what? That's another little thing on personal injury. I've collected a lot of money for folks over the years. I mean, I once collected somebody almost $1 million for one person, one accident. And lots of $100,000 ones and lots of smaller ones, but lots of big ones. And I would never, ever, ever trade my physical health for what kind of condition you need to be in to get $100,000. You know, everybody thinks that you're going to spill a little hot coffee on yourself, get a little burn on the leg there, maybe a little higher, and that suddenly it's going to be like $2 million, $50 million, $16 million. Oh, I go nutty, people coming in the office. Mr. Rominger, my injury, blah, 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 blah. I don't know. I say, what do you think it's worth? That's a good question I like to ask. I like when they say, I have no idea. I'm like, good. You should have no idea because we don't even know a lot about your injury yet. Other times they say, well, $250,000 sounds fair to me. And I mean, that's low, but we settle that. You'll get like 80 of that, and I'll take like this, and it'll be fair. And you're in your mind, you're like, okay, let's see. You lost work for 2 weeks. Your knee had already been operated on twice. You're 48 years old. You're 300 pounds over ideal weight. I don't think it's worth $250,000. How about $25,000 if we're really lucky? Anyhow, you can see where I'm going with this. You would never ever want to trade positions with anybody with a personal injury lawsuit if they got a lot of money, legitimately got a lot of money. And I'm sure there's a few that sneak through that shouldn't have, but there's a lot who don't get anything who should have gotten money. So join me again here on Weekend Appointment. I'm attorney Carl Rominger. In the meantime, go to weekendappointment.com and download prior podcasts to listen to. You can hear all the old shows. They're all archived. You can find them on weekendappointment.com. And, of course, you can reach me throughout the week. I'll see you next week.